Welcome to topic 2, proof, relevance and admissibility. These ideas are the heart of evidence law. They answer two essential questions. 1. Who must prove what? And how do we decide whether evidence can be considered by the court? In civil cases, the plaintiff carries the initial burden to prove the elements of their cause of action. Sometimes the burden shifts. For example, if the defendant raises a defense, we distinguish between the legal burden, which is the duty to prove, and the evidential burden, which is the duty to produce evidence supporting a claim or defense. The standard of proof in civil matters is the balance of probabilities as set out in Section 140 of the Evidence Act. The principle from Briginshaw reminds us that serious allegations such as fraud require more persuasive evidence, even though the standard remains balance of probabilities. In criminal law, the presumption of innocence is paramount. The prosecution carries the legal burden of proving the offense, consistent with the principle in Woolmington versus DPP. The defendant may carry an evidential burden if they wish to raise a particular defense, but the overall legal burden remains with the prosecution. The standard of proof in criminal law is beyond reasonable doubt, set out in Section 141 of the Evidence Act. Shepherd versus the Queen illustrates this with the analogy of chains and strands of reasoning. Circumstantial evidence can be enough if taken together. It excludes reasonable doubt. Relevance is the foundational principle of admissibility. Section 55 of the Evidence Act states that evidence is relevant if it could rationally affect the probability of a fact in issue. In IMM versus the Queen, the High Court clarified that judges must assume evidence will be accepted when deciding relevance. Reliability is a separate issue though. In practice, relevance depends on the legal issues at hand. In civil law, this means the elements of the cause of action. In criminal law, it is usually linked to actus reus and mens rea. In Smith versus the Queen, the court considered whether certain evidence was truly connected to the issues before the jury. Circumstantial evidence requires an inference to connect it to a fact in issue. Interestingly, it can sometimes be more compelling than direct evidence. Shepherd versus the Queen and R versus McCarthy and Ryan illustrate the strength of circumstantial reasoning in criminal trials. Sometimes evidence is conditionally relevant. Its significance depends on another fact being proved. Section 57 addresses this scenario. For example, a ranch may be relevant only if it can also be proved that it belonged to the accused. Section 142 provides that such admissibility is judged on the balance of probabilities. Courts often resolve this through a voir dire or trial within a trial. That concludes topic 2, that is proof, relevance, and admissibility. We have seen how burdens and standards of proof differ in civil and criminal law, and how relevance is the key to admissibility. Good luck. Thank you for watching, and see you in the next lesson.